Welcome back to part 2 of this law session on answering contract law exam questions. Now, before the break, I said to you that when we return, we would look at how we answered a question on contract formation. So what we are going to consider then is, how do you approach a contract formation question? And in particular, we will consider a question which was posed on the University of London LLB programs, external international programs in 2011. And it is question 1, and it comes from the 2011 contract exam paper, and it reads, on Monday, Angela telephoned Barney in response to an advertisement in the Weekly Chronicle, a local newspaper. Barney's telephone was answered by Clara, his absent-minded wife. Angela introduced herself and stated, I agree to buy the advertised car at the advertised price. I'll send a fax confirming this. Those were her words. Claire replied, great. I'll let Barney know when he gets in. When Barney returned home, Claire could no longer remember the details of her earlier conversation and told Barney, some woman rang about the car and she's willing to buy it. On Thursday, Barney found the fax and replied immediately by email saying, I agree that the car is yours at the agreed price. Unfortunately, Angela received only part of this message due to a defect in her email program. On Wednesday of that week, the value of the car had dropped by half because of the introduction of a new model. Angela refused to take the car, advised Barney. Now, contract formation questions tend to be a staple of any LLB contract law exam paper. The examiner details various communications which have taken place between 2 or possibly 3 or more parties, and then the issue invariably turns on the effect of those communications passing between the parties in order to determine the contractual status between the parties, because one party is of course now seeking to enforce something from those various communications as a contract, or somebody in the whole spiel that the examiner is giving you is not abiding by the agreement. Now then, how do you start? Well, the most important thing to bear in mind in contract formation questions in particular is that you should determine the status of each communication. So what do I mean by that? I mean, don't let the examiner tell you what it is. So for example, a question might say, X placed an advertisement on his windscreen offering his car for sale for £10,000. B was passing by his house, saw his car, called A to accept his offer. Well, by any stretch of the imagination, legally, this is not an offer when the advert was placed on the windscreen, and certainly it was not an acceptance when he called, given what you know about adverts and what you know about offer and acceptance. So just because the examiner uses the word offer in respect of the advertisement being placed on the windscreen and uses the word acceptance in relation to the telephone call does not mean that's what it is. You have to explain the effect of the advertisement on the windscreen, and you make your own submissions and tell the examiner the status of the communication, not simply take the words of the question used as being that is it. Now, the point is that if the examiner had said something to you like the windscreen said, advert said, first come will get, that's different. Because then, of course, his use of the word offer for sale would arguably be correct. But the point I'm making is, even if he says that, you still test it. Now, what you have to do is to consider the chronology of the events as they happen. Because Although the call is from Angela, we see that it is in response to a newspaper advertisement, as we are told in response to an advertisement in the Weekly Chronicle, a local newspaper. What you will need to do is to tie down, to set out, that is, an analysis for that first communication, as everything you do will flow from that. Because if you start off saying it's an invitation to treat, then Angela's response is an offer. Equally, if you say it's an offer, Angela's response will either be an acceptance or a counter offer. So that is why examinees' answer papers will differ. Because one person might say it's an offer, depending on the discussion, of course, that he gives. And another might say it's an invitation to treat, again, depending on the discussion he gives. Much depends on your discussion and your submissions. So are you saying it's an offer, or are you going to say it's an invitation to treat? Notice how the examiner frames Angela's response when she calls responding to the ad. She says, I agree to buy the advertised car at the advertised price. I'll send a fax confirming this. Now, you would need to discuss the main cases for offer, because it appears she thinks she's accepting, so you should need to discuss what is required for an offer, as she can only accept an offer, and also discuss invitation to treat, given that we are told it is a newspaper advertisement. So you would have to briefly focus on the relevant cases. So for example, Storer and Manchester City Council and Gibson and Manchester City Council for offer, and then also bring in Carlisle and Partridge and Crittenden for the invitation to treat discussion. You also need to make submission. Now this seems to be one of the biggest downfalls of law students, failing to what I call nailing their colors to the mast, as it were. They discuss, but they make no submissions. Now it is good for you to make submissions. So once you have done the discussion, submit that. Submit that based on how you have argued it is an advertisement, or submit based on how you have argued that it is an invitation to treat, and then move on to discuss the status of the next communication in light of your submission. So if you end up saying the advert is an invitation to treat, then discuss the next issue as the offer that Angela makes and how that offer comes into being. Particularly, you would need to focus on the offer being communicated as the message was given to Clara. If you submitted that the ad was an offer, then you would need to discuss the effect of the acceptance by Angela, and again as to the message given to Clara. The question says advise Barney. So that's what you need to do. Remember what I said, answer the question. And what you need to do then is, in answering the question, advise Barney. What are you going to advise him about? Well, look at the end of the question. It said Angela refused to take the car. You have to advise Barney about this. The issue is there a validly formed contract? Because if there is, Angela will be liable to Barney, but if there isn't, she is not. Now go back to my Jeopardy analogy at the beginning. I would certainly suggest that an introduction that started along the lines of, in advising Barney as to whether there is a validly formed contract between him and Angela, giving rise to liability on her part, it is necessary to consider the status of each communication between them in determining whether such a liability exists. I would then continue and consider the chronology of each communication. Now, in the discussion relating to advertisement of the car in the newspaper, as I've already said to you, you would want to draw on the law relating to invitation to treat and offer in discussing this. Now, based on Carlisle, we know that an ad can amount to an offer, but it must meet the criteria for an offer. The question is deliberately vague, and so it is possible to submit that it is an offer. But the safer approach, based on the facts you have, is to submit that it is an invitation to treat. The offer would then be when Angela speaks to Clara, and of course, it must get to Barney. But even if you said the ad was an offer, you would need to mention the cases you know about third party passing on, meaning, for example, the case of Dickinson and Dodds and the reliable third party in respect of the message to Clara. The examiners also raised the issue of communication by fax. You would need to consider the rules and cases in relation to instantaneous communication the minute a fax machine or even email is used or mentioned in a question. So you would need to discuss Enters and Miles for Eastern, Brinkeman and Stagstall, and the Brimners as well. If Barney was purporting to accept Angela's supposed offer, then you would need to explain the issue of the failure of the entirety of the email to get to her and the defect in that communication. Now, that is my suggestion on your approach to the question. We will take a short break. On return, and we will consider a past question in relation to misrepresentation. However, if you're signed up to our premium service, then you can contact us to request a copy of a sample answer to this particular question, which I have written under time conditions in under, of course, 35 minutes. We will continue after the break.